Welcome, everybody. Thank you for coming. This is the volunteer training for our Educational Equity Project here at the Chicago Lawyers Committee for Civil Rights Under Law. Lots of long names. That means we do lots of good work. I'm pretty sure the more names you have, the more work you do, right? Not really. But okay. Yeah, so first of all, thank you guys for coming. My name is Candace Moore. This is Jessica Schneider, and we both are staff attorneys with the Educational Equity Project. We also are very happy to have Lee Robbins with us from Equip for Equality, who's going to give us a little bit more information specifically about special education a little bit later on. But our main purpose is really to make sure you understand sort of the lay of the expulsion representation. In particular, we'll talk about some other types of representation that have to do with access to education for young people, but we have a project here in which we utilize pro bono attorneys to do the cases, to do these expulsion cases, and that's how we're able to have a larger reach for the students, because if it's just left up to me and Jessica, we soon reach capacity, and it really is through our volunteer attorneys that we're able to take on and really help more young people who are facing expulsions and also facing restrictions with getting back into school. So just to go over what we're going to do in terms of an agenda, I'm going to begin by giving you guys a deeper intro into CLC, into the education project, and sort of why we do what we do. Then Jessica is going to give you the rundown on the general education representation, and that's important to note. So we do general education cases. There are special education cases, and one of the reasons why we do that is because other organizations, such as Equip for Equality, Chicago Coalition for the Homeless, have really specialized on particular populations. But when we created our project, when the project was born, we sort of saw this need for the students who didn't fit within those categories, who still needed representation. And so really our project is first and foremost to sort of address that need. And we collaborate with Equip, with Chicago Coalition for the Homeless, LAF, and some other organizations who specialize in particular. So we're all sort of a community and support each other. Then Lee is going to, so after Jessica gives us the rundown for general education representation, then Lee is going to go over special education considerations that we should keep in mind. We don't do special education here, but you'll often run into it, so it's at least important to know what's going on there and sort of have a basic framework. And then so you can sort of better address some of the needs of your client, and also know when you need to make a referral or when special education issues coming up, such that we reach out to Equip or to some other organizations to deal with those issues. And then we'll sort of open it up for questions in the closing. We're very timely. It's going to run perfectly smooth. I'm really excited about this. But yeah, so to begin with, and I'll use this as a clicker, we're going to talk about school discipline. So I start with the school to prison pipeline.
Audio. You want to do the audio?
Yes. Okay. So I'm going to start with the audio, which will introduce us into the school to prison.
So we're going to play. There was recently a This American Life episode that some of you might have heard about school discipline. I'm just going to play part of the prologue for, especially if a lot of people have heard it already, but it introduces the topic really well. I'm also going to pass around a sign-in sheet, and this is an article from Catalyst, who does a lot of really good school reporting and school discipline reporting. If you want to check them out online, they're associated with the Chicago Reporter, and this was their part of their in-depth issue that they did this summer, which was all about arrested school and school discipline. And we made a copy for everyone.
Okay. Let me know. Yeah, let me know when you have it out. So yeah, I'll just begin and start. Jessica's gonna work on getting that up for us. But we we start with the school to prison pipeline because when we were thinking about doing this project and what we wanted to do, this issue sort of came up again as a big civil rights issue where we thought we could be really. And how many people have heard of the school to prison pipeline, just by a show of hands? Awesome. I think it's been interesting for me because when we first started the project a number of years ago, we would ask that question and there'd be a lot less hands. And I think that's really one of the reasons for that is a lot of movement has been going around school to prison pipeline. There's been more federal attention to it. A lot of community groups have really been pushing the issue. Lawyers have gotten involved, and so there's just been a really concentrated effort around this idea of the school to prison pipeline, really getting the word out about it. But I like to make sure we're all on the same page because I think sometimes people talk about a cradle to prison pipeline, which is true, or they talk about sort of a birth to prison pipeline, which is just sort of is a bigger spectrum. But when we're talking about the school to prison pipeline, we're talking about kids who start at school and through a series of policies and practices and really conditions within the school are pushed out of school and are left vulnerable to entering into the prison system, particularly the juvenile justice system, as a point of first entry. That happens for a number of reasons. I sort of think about it. There are kids who come in with sort of preconditions almost. I mean, those are going to be conditions of poverty. These are young people of color. These are people who are coming into schools that are under-resourced, teachers who have classrooms that are overcrowded. All of these conditions create strains on trying to educate a child, such that when a child misbehaves or acts outside of the scope of whatever the disciplinary rules are, they're met with exclusionary measures. So let's discipline this child, let's react, let's curb this behavior. But largely what was happening is that included removing the child from the classroom, removing the child from education time. And beyond just removing them from the classroom, we were finding kids were being removed from the school altogether. So through suspensions, through expulsion, and then sometimes through arrest, youth were being picked up right out of the school and sort of left either out in the community or being transferred directly into the prison system. And we know that once a youth touches the prison system the first time, it increases the likelihood of recidivism, increases the likelihood of a cycle. So there has to be some really concerted efforts in order to really protect that child from what we know is the system that happens there. We sort of saw our role as what could we do? How could we be effective as lawyers in this process? And we thought the point of expulsion was critical. So at expulsion, you have an opportunity for representation, and so really focusing at that point in which you have an opportunity to have an advocate by your side to explain what was going on, to explain the situation, to sort of slow down the process and think about different alternatives. It was going to be a really critical moment. And you'll sort of hear some of the things that I talked about in terms of the school.
No, sorry, not yet.
Okay, so that may or may not work.
This American Life app is terrible for those who have crashes all the time.
But if we can't bring it up today, I do encourage you guys to listen to the podcast about this. I think they did a really good piece on that. But so this is giving us more of a graphic look at the school to prison pipeline. So again, a lot of things that I talked about, this sort of prison-like environments is over there. It's a little hard to read, but when we're over here, we're talking about prison-like environments. So schools with surveillance cameras, police dogs, armed guards, schools and local police on campus, metal detectors, strip searches, physically uninviting buildings. This is what our kids are entering into, and particularly the kids in some of the most under-resourced schools. They're walking into a place that looks like a prison, feels like a prison. They feel like they're being watched, and what that does to a child, it has major impact on how they behave. To say that you expect them to feel comfortable and safe in this place, and you have all of those things around you, is strange. I don't know how many people feel safe in a prison, but that's what we're having our kids experience on a daily basis. And then there's underinvestment. So there's cutbacks on counselors, social workers, mental health resources, underfunded and under-resourced schools. So some of the things that we know would help kids with some of the difficulties that they walk in the door with, we don't have an investment in those things. We don't have, there's one counselor for multiple schools, maybe not even one counselor per school. I've sort of heard horror stories about, the social worker having to travel around and have a circuit of like 4 different schools and sort of expecting that they're able to meet the needs of all the students there. And then harsh school discipline. So when students are acting out, we meet them with out-of-school suspensions, expulsions, transfers to alternative schools, zero tolerance policies, when we know that there are other options. So it's not like these are the only things administrators know, or that's the only thing that's out there. There are other alternatives. There's a big push for restorative justice, and we won't go into a lot today, but there's a big community pushing restorative justice that really focuses on having the child who misbehaved or created some sort of harm really be the center of restoring that harm and thinking about how do we keep them a part of this community, but also make them understand what they did was wrong, why it was wrong, and what can be done to fix it. And then pressures and uncertainty, school closures, privatization, high-stakes testing pressures, implicit and explicit bias, and all of these things. So this is national look at it, but it's something we know very well here in the city of Chicago and in the surrounding area. And then, again, sort of what kids are coming in the door with. Youth of color, LGBT students, and students with disabilities are disproportionately affected by all of this. And I'll give a fair credit. I did not create this graphic. The advancement project did. It's wonderful. I love to use it, but I always give them credit because I don't want anybody to think that I can like replicate this anymore. And then, so this is the second part of that graphic, and it gives us some numbers. So looking at out-of-school suspension, I think the year that they were looking at in particular, so this is a little data, 7 or 8 or something like that, but at that time, students had received an out-of-school, and that's students, that's not the number of school arrest. Over 70% of students involved in school-related arrests were referred to law enforcement. They were Hispanic or African American. We can see some of the data around proportionality. So when it comes to suspension, 1 in 20 white students had faced a suspension. Go down to Latino, 1 in 20 American, 1 in 13, Black, 6. Black with a disability, 1 in 4. We really can sort of see some of the national. And then I always think this is interesting. So what are kids getting suspended, expelled for? They must be doing something like pretty terrible. And the reality is that's really not the case. So they tease out some issues, but students have actually been suspended for talking about a Hello Kitty bubble gun, hugging a friend, chewing a Pop-Tart in the shape of a gun. Real stories. Students have actually been arrested for a kindergartner throwing a temper tantrum. There's actually a video on YouTube that I was going to show of a 5-year-old who was arrested for throwing a temper tantrum, and it's the impact that has when you look at it is just huge, and to see how everyone defended that decision, thought it was a good idea, thought that that's what needs to be done in that moment. Scribbling on a desk. Students were arrested for sneaking into school for a senior prank, playing the Fresh Prince theme song on a cell phone. Yeah. And a science experiment gone wrong. And I think a lot of this arrest and over-arrest that we see really comes out of this fear of school shootings, this fear of school safety. So I think it comes from a real place, but it's a drastic overreaction to individual situations that are happening. They're sort of thinking about the worst case scenario and punishing as if that's what was in front of them, and really tapping into those fears. So this is what it looks like locally. So what we have here is the map on the left is a map of Chicago that is with the colors indicating racial content. So the pink reddish is white, is what indicates white folks. Black is blue, Asian is green, Hispanic is orange, and gray is sort of other. And I think it's just, they didn't count that part. But so you can sort of see the racial makeup of the city. If we look north, we see a higher concentration of white folks and Hispanic folks. We're looking directly west, we see right there where the blue is, a concentration of African Americans. Just sort of south of that, of Hispanic folks. Just sort of in the middle here, we see a concentration representing on the south side, largely on the south side, African Americans. The map right here on the right, is that the same? So these dots indicate schools that had 5 or more expulsions within a given year. The red is your Chicago public schools, and the blue indicates charter. What I think is interesting about looking at side by side, well, I guess I should ask you guys, what sort of stands out there?
High concentration of expulsions in the south side.
South side, and then even I think when you're sort of looking west, you sort of see it right there too, and primarily in areas where Black folks are concentrated. And I think that's important in naming the issue and really understanding the issue, is that when we look at the numbers here in Chicago, we are really looking at an African American disproportionality. I'll show in some of the other data that we have, it really is more stark for African Americans than even any other minority. And I think that's important when we think about policy, when we think about how we advocate, when we think about who our clients are. It's just really understanding that this does have a disproportionate impact on African Americans. How am I doing in terms of time?
Yeah.
Okay. Okay. So here is some data. Here's some data that, again, I did not do this. So the last graph I did do, except for the one with all the race part, I just sort of copied that one. But the other one I did do, so yay. But this one was done by Project NIA. And they just put together some data, some stats. They actually have a more recent one that I wasn't in PowerPoint in time, but if anyone's interested, I can send that out. But they're just looking at school-based arrests, so arrests that are happening at school. And so in 2010, we have 5,500 or more, and you see the numbers slowly going down, but still on average, 25 students are arrested in Chicago schools each day. And then here we have in 2012, young men comprised 68% of those arrested on CPS property. Black youth represented 42% of CPS students, but accounted for 75% of school-based. A little bit more to show you. So these are some graphs we put together. So one of our advocacy efforts was working with a coalition of community organizations to push CPS to be more transparent about their data in relation to school discipline. After many years, I think we sort of joined in sort of the latter part of it, but after many years, they agreed to be more transparent, and this is a data that was put together out of their first major release on the breakdown of, which included charters. They have committed to doing this annually. We are still waiting.
No, by the way, I got an email very early this morning from Miriam Kava from Mia, and apparently the data is up on the website, so we'll have to check that out.
Excellent. So there will be updated graphs.
CBS is like, you didn't know it was there? I think it's there. Go look.
So that's excellent. So we can look at some of the things. One of the things that I think is exciting for us is that there have been a lot of concentrated efforts from CPS to sort of fix some of these issues. So we'd really like to see where the data is showing us on how they're doing there. But if you look at this first graph, it is a graph of district enrollment. So it shows us just how. Looking at 46% African American, 9% white, less than 1%, 3% Asian, and 46% Hispanic. Now we'll go over to in-school suspensions. Go ahead. Oh, no, sorry, this is not her question. Now looking at in-school suspensions, we see that that impacts 3% white folks, 71% African American people, Native American less than 1%, Asian 1%, 25%. Just sort of looking at the numbers of, so red is African American, blue is white. So if you guys can all see that, that light blue color is Hispanic, and the green is Native, pinkish is Asian. But if you just sort of look by graphs, and this is expulsion, you see the disproportionality, particularly for African, with their percentage of in-school suspensions, out-of-school suspensions far exceeding their relative representation in overall. So again, that helps us name the issue and see where it's at. That we're really talking about African American students having a disproportionate. Not saying that the policies don't affect all students, but in CPS, this is what it looks like. In different areas, it looks different. And so you can get more data per school from sources like the Department of Education OCR website, breaks it down by district. But all their data that's disaggregated. And this is a look at students with disabilities. So we're looking at within CPS, 11% of students had an IEP. And I think it's important to say had an IEP because there are a lot of students that are not identified as having a disability. And that's not the number we're counting. We're only counting the ones that got an IEP. So 11% of students, but when we look at over to in-school suspensions, out-of-school suspensions, with them representing school suspensions, 19% of out-of-school suspensions. So now that we know all of that, what do we do about that? I sort of talked a little bit about it, but just to go into it a little bit more, our mission is to protect and promote education by addressing individual and systemic barriers that disproportionately impact disadvantaged community, racial communities, poverty, LGBT folks with disabilities. We do this on different levels. So one, we have our pro bono cases, which is why we're here, which is what we want to talk about our individual. We represent folks in expulsion cases primarily, but we also have gotten into now doing some re-enrollment work, recognizing that there are a number of youth who have either already been expelled or been transferred out or dropped out who want to get back into school but can't for a number of reasons, and we have expanded our services to really help that population as well. A little different in that there's not necessarily a hearing, but there is a lot of need for advocacy. Negotiating, writing to schools, and really sort of standing by the parents in their efforts to get back to school. And then we do some anti-bullying advocacy. This is really more on a case-by-case basis. We would like to expand, but right now we just and then we also engage in affirmative litigation. Right now we don't have any. We are focused on doing Department of Education and DOJ complaints. And overall litigation based on discrimination. We promote systemic reform, so we do a lot of working with policymakers, looking at changes to the student codes of conduct. CPS last year went through a major overhaul of their student code of conduct. It's not perfect, but it's a lot better than what it was. So that's one of the reasons why we're really interested in this data that's coming out to see really how some of those reforms have worked. We address systemic discrimination and unfair disproportionality. We do stakeholder development, so training for teachers, students, so sort of train anybody who we can, who wants to, and we talk about what that looks like. And then contributing to reports, and then really focusing on racial justice work because we recognize the racialized nature of this problem. And then through all of our work, we want to empower communities and build partnerships. So we work with a ton of community organizations. One group is SUFEO, which is a group of law students who got together and said, we care about school discipline, we want to do something. So they're focusing on advocacy, which a lot of the organizations just don't have the resources to do. Conventions are sort of much quicker and don't necessarily have hearings, and so this group of law students said they want to focus on that. So we are serving as an advisor to their group that's doing that. It's based out of Loyola right now, but I think they have hopes of expanding it to other law schools. There's a restorative justice initiative that we're a part of, so on and so forth. I won't go through all the details. I don't know how I am. Okay, all right. And I think I'm done. So that's just sort of the overview of why we do the work that we do. And now Jessica's going to talk about how we can do the work.
Yeah, I'm going to try and play.
Your middle school teacher. Here's the situation. Walks into your classroom wearing a hat. There's a rule. Hats are not allowed. He doesn't. Was not acceptable. Tolerate that. Have a conversation. So, let's have a conversation about your hat. Absolutely. The Dreamers. Oh, it's narrative. Ladies and gentlemen, today. You know, look. What? Wait, did you take your shoe off? Socks? And take off my shoe. Never know. I've probably plenty of shoes.
I'm not positive though.
That's teachers. Okay, so really, how do you confidence with a name? Kids name. His name's Jeff. Others. Johnny. We'll call him Johnny. What to do. So work with kids. No. That's the practice that educators agree on. Talk about on the radio and in the media. Today we're going to talk about discipline. How discipline before you can do anything.
So yeah, I recommend listening to the whole episode. It's really interesting, and they cover charter schools and different schools, but it kind of gives you the overview of how there really is no kind of curriculum or training on how to handle your classroom and how discipline works. And so each teacher or administrator might just develop their own approach for the same situation, and some might work really well and some might not work at all. So we're going to go over just basically how school discipline law works. Unlike a lot of fields, there isn't that much law out there, but there is some. And then we're going to go through how the expulsion process works. Before we do, though, can we just go around the room really quick and people say who you are and where you're from, so we have an idea?
Yeah, my name is Jeff. I'm from Chicago, and currently completing my JD and MBA.
I'm Megan. I'm from Nebraska, and I'm currently volunteering with CARE.
I'm Caitlin. I'm an attorney in town. I just graduated this past.
Chris, and I'm originally from Akron.
My name is Susan. I'm from the suburbs. I'm currently a staff attorney with First Defense Legal.
My name is John. I'm originally from Michigan, and I'm a third-year law student.
So when we're talking about CPS specifically, which is how we started out and where a lot of our cases come from, you know, it's the third largest school district in the United States. It is a massive amount of schools and children, and so I like to pull this out from their own wording, which is our vision is that every student in every neighborhood will be engaged in a rigorous, well-rounded instructional program and graduate prepared for success in college, career, and life. Needless to say, I don't think they are quite succeeding at that goal right now, but we like to try and hold them to it. I think especially it's interesting that they say every neighborhood, because neighborhood by neighborhood, the disparities are huge in terms of their education and services. So we're just going to go over really quick the Illinois School Code, CPS's Code of Conduct, how their discipline system work, which is a good baseline. And then Lee's going to talk about students with disabilities. There is, beyond CPS, there's a lot more stuff out there. Each school district will probably have their own code of conduct. We do hearings in suburban school districts, charter schools, and for those you need to know separate board policies and procedures. We started just with CPS, but the more we got into this work, we got more and more calls from charter schools, suburban districts, and that's actually probably making up an even, if not slightly bigger percentage now of our work, because CPS is making some changes. And so now we've built that into our practice as well. We're not going to talk a lot about police and arrests, but just to note a couple quick things. There are times when school administrators are supposed to contact police when there's an incident at the school. The big change this year is there's no longer mandatory police notifications, which was something that a lot of people advocated to get rid of, except now so for non-emergency situations, there are no mandatory notifications, but for drugs and firearms, there is a mandatory notification because obviously they weren't going to cut that out. And there are specific guidelines that administrators are now supposed to use. It's debatable, you know, whether when an incident happens, an administrator is going to say, okay, let me get out my 6 factors, you know, and see if I should call the police. But they are trying to provide stricter guidance so the police are not being called for minor incidents. So these are the factors. You know, you can they're pretty common, whether there was drug possession or drug lookalikes are also included. If there was harm to the school community, whether the student was in possession of a firearm, and they do define firearm in the reference guide for administrators, then you have to notify the police if there's a firearm situation. These are guidelines that the school officials should be considering. And then it goes on to say, was there imminent danger? Was there physical injury? How old is the student? If it's someone 5th grade or below, They're supposed to consult with the law department, which is a CPS central office, before reporting to the police. So they're supposed to call, explain the situation, and see if they should be reporting on a kid this young. That is probably one of the clearer guidelines. For the rest, obviously, they're kind of evaluating that as the incident has happened. And so hopefully this will bring down the number of arrests at school and the number of times the police are called. That's data that CPS has not given us and has, for some reason, said is difficult to gather, even though when they fill out a misconduct report, they check a box saying if police were notified. So we're not sure why it's difficult, but we're still working on that to see if this actually brings down the number of police notifications. So whenever you're working with a student in a school discipline situation, you always need to find out were the police called, because a lot of times that's a parallel situation that's going on. So the Code of Conduct, which is on the CPS website, it's a very long document, but it spells out exactly every violation that you can think of, and then what is an acceptable punishment for that offense. It's a great thing to read. It's something that will be very useful and necessary. There's a copy of it. If you are, yeah, you can pass it around. If you're doing this kind of work, parents and students are required to sign an acknowledgement of receipt, and that is used as proof in a hearing that they have seen the Code of Conduct, they read it and understand it, whether they read it or not, which they probably didn't. A lot of parents find it too long, too wordy, and that's also something that CPS has been working on. Charter schools, some of them use this Code of Conduct and some do not. And there's a push to try and bring more charters under the CPS Code of Conduct. But the thing is, they don't have anything, there's no stick to wield if they don't. They can't force them to. It's something we advocate for because we think this Code of Conduct is a lot better, at least, than a lot of charter schools and what they're using. It applies, some question of, okay, when does this apply to students? It's the whole school day. While on school property, while traveling to and from school, we've seen incidents on buses, incidents waiting for the bus, at any school-related event, like a sporting event, some other event at the school or not at the school. We just talked about buses. And then while using the CPS network, which refers to computer violations. And so it's pretty broad. It can cover things that you wouldn't think it would cover in terms of if the student's just traveling to or from school, or is that off school but at a school related event. So these were the changes that Candace mentioned. CPS put a lot of effort into trying to bring all administrators under these guidelines for effective discipline. I'm not going to go through every single one, but just you can see up there that they're really trying to make the principal or the principal's designee to try other interventions before getting to out-of-school suspension or expulsion, and also to try and discuss with the student before assigning some sort of consequence. So they're supposed to go through all of these steps, and they supposedly received training on this last summer about what consequence is appropriate. Could we do something besides a suspension or an expulsion? So it's just good to know for people doing this work now. They also need to report any inappropriate behavior. There should be a complete report. There have been issues with that before where administrators don't put in all the information. They just put in what they feel like it, or they don't report it at all. They're supposed to inform parents and guardians of their right to appeal. If someone thinks the consequence is excessive, they have a right to appeal. And that group that Candace mentioned, Sufeo, is helping parents and students with suspension appeals. And now they're supposed to have reentry meetings. So when a student is suspended or expelled and they come back into the school, if they've been out for 10 days or 5 days, it's not just assumed, it should not be assumed at least, that they can just go back in and everything's going to be fine. So now they're supposed to meet with the student and the parents to make sure that they're restoring the student's participation in school. Again, this is all brand new for this school year, which we're about almost halfway through, and so we're interested in seeing how that plays out. And in extremely clear language, it says out-of-school suspension is a last resort, and only when in-school interventions and consequences are insufficient. And that's the strong language that they're using. So when you get into the nitty-gritty of the code of conduct, it's 6 groups of offenses. 1, 2, and 3, you're talking not as serious. And then when you move into 4, 5, and especially 6, that's where you're going to see most of your expulsion possible offenses starting in. Suspension starts out of school starting with group 4, and then when you move into 5 and 6, you can get possible expulsion. Each group, it spells out right next to the offense, here are your possible interventions. So they're very clear. This isn't like a system where we're not sure what can happen. There are very strict guidelines, and so part of this is just making sure administrators are following those guidelines. These group 5 and 6 are most seriously disruptive. They really like the adjective verbs. And illegal and most seriously disruptive behaviors. You may be suspended up to 10 days, but a plan must be created and written justification must be submitted. You can do less than a 10-day for any of these offenses. That's also something that's new. You can do 5 to 10 days for group 6 and 3 to 5 days for group 5. And that can be combination in school, out of school, whatever they want to come up with. But those are some changes trying to limit the offenses. So supposedly, if you have an in-school suspension, you're doing skill building. So you're supposed to be engaging in some sort of activity. You're not supposed to be just sitting in study hall or doing homework. Probably is what most kids are doing. Reasonable efforts have to be made to contact the parent or guardian. Same thing for out of school, except you're actually removed from the school. You are supposed to be able to get your homework. One of the big principles that we believe in is that an out-of-school suspension should not be something that causes you to fall behind, and you should not suffer, your educational consequences because of behavior. But it can be hard to get the work, and the parents have to be proactive about it. It's something we try to be proactive about if it's our client, but if it's not our client, who knows how much work they're getting. So, but they are excused absences. You can't suspend for more than 10 days. They have to be able to come after that. So this is where the Illinois School Code, and there's a site there, talks about suspension. So again, you have to immediately report it with a full statement. This is interesting because in other school districts, because they're much smaller, you have a school board where you could actually probably request a meeting with the board or almost a hearing to review and appeal the suspension. You don't see that at CPS. They don't do a hearing in front of the board because it's a massive school district. You have to do just a meeting with the principal or a written appeal. And so, but some people think, based on the state law, they should be doing those hearings for suspension appeals also. So it's kind of an interesting area of what's going on. But basically, this is what state law says about suspension, so it applies to all schools, including CPS. These are also new changes. Pre-K through 2nd grade, you cannot be suspended anymore, which seems like it wouldn't be necessary to spell out, but there were younger kids getting suspended. There is a very small exception if there's some sort of emergency, and to do that, you have to contact the network chief and notify the parent or guardian. I don't know what would qualify as an emergency in this situation, but it'd have to be something pretty extreme. And so that way they limit for younger kids the use of taking them out of school. It says they have to notify parents. How do they do that? Basically, it's a written notification. It has to include the reason they're being suspended, the number of days, a right to appeal, and then a copy of the misconduct report in CPS, which is a standard document. And so all of that should be provided to the parents. So one of the first things we ask them is, did you get this written notification? This is a misconduct report. They've changed a little bit. This is an older version, but basically, they spell out a brief narrative. They check some boxes about why they were suspended, how long it's for, whether the police were notified, and everyone has to sign off. In terms of case law, you know, there's really not too much out there when it comes to due process for taking away your education. Goss v. Lopez is one of the main cases which talks about your education is a property interest, and so you can't take it away without adequate notice and opportunity to be heard. And this is where they created the 10-day rule. So 10 days for short-term suspensions, anything more than 10 days is considered an expulsion. And so you need to have some of those procedural protections, which takes place as a hearing, which is where volunteers come in. You can appeal a suspension. You can ask the principal for a meeting. There's this new office CPS created called the FACE office, which is Family and Community Engagement. And so you can supposedly call them and get information about, I've heard not so good reports on the actual staff in the FACE office, but we're still, the jury's still out on that. Or they can call the network chief. Each CPS school is organized geographically into a network. Again, this is a lot of proactive steps that parents need to take. Some of them are great at it, but some of them aren't and need assistance. And so it's a lot to ask, you know, perhaps a parent or a student to be able to follow these steps, but it's important they know that they can. Yes, question?
Sorry.
No, go for it.
I don't know if you guys are going to get into suspension or expulsion model. What about the, I've heard of this concept of series,
Mm-hmm.
and instead of just having a violation or like, you know, this whole thing about taking off your hat, like following a simple. So I'm not sure if that's worked into this code of conduct or for that as an alternative.
So it is, it's listed as possible alternative in the code of conduct. Basically, all restorative justice practices are available. And this year there was a more detailed guide put out for administrators about how you might use that and giving examples of scenarios. The issue is that a lot of schools aren't set up to do peer juries. They don't have people to come in and explain how it works. And so we like to think of it as an unfunded mandate because they're supposed to be using these practices, but not. Some schools do it really well, and some just don't have the people or the resources. But yes, that's supposed to be an option for pretty much every offense, and that's something you can advocate for as well. So when it comes to what we're really using, you know, our lawyers and our volunteers for, the expulsion is a removal for 11 or more consecutive days. Typically, you see semester, 2 semesters, up to 2 years, which is the maximum. A lot of people don't know, and I didn't know before I started this work, so that's the longest you can be expelled for. Except charter schools, who are exempt from pretty much all of this part of the school code, can expel permanently. But then a student can enroll in a CPS school, but it's a problem. So they actually are the only ones that have the option to do that. You can refer for an expulsion for a Group 5 offense for CPS, and you must request it in certain situations with a Group 6. And the other thing that CPS can do that debatably is a change from what they could do before is they can assign a student to an alternative education setting without doing a hearing. We would argue, and if it comes up, been looking for it, that a hearing would be required because that's an expulsion from their school. But it is written into the code of conduct that they can transfer someone to an alternative school if it's an extremely serious misconduct or offense. So how does it work? You get the notice. Expulsion hearings for CPS all take place downtown in their central office. There is a hearing officer. The student and parent can be represented. You present your evidence, you can present witnesses. It's a very loose administrative hearing, so it's hearing officer and a representative from the school, usually the principal, sometimes it's the assistant principal, sometimes it's a dean, and then you're there representing a student. Someone from the CPS law department is there representing not quite the school, they're actually representing the board and the CPS law department. So you do, most of the time they don't want you to do an opening because they think it's not necessary, they don't need time for it. But it should go opening, each side presents their witnesses. You can do cross of the school's witnesses and then closing, which again, sometimes they're like, okay, fine, and they roll their eyes and hurry up. It's like sitting around a table like this in a room smaller than this one. It's very informal, but it is a good way to kind of, get some advocacy experience. Yes.
I'll just throw it real quick with they do try to cut you off from the opening and sometimes the closing, but I think it's really important to push for it anyway because I've had cases where in the closing, I mean, like it's weird to like sort of do this whole testimony and not be able to say why this all fits together. So and I've seen them, even though when they told me you don't need a closing, in my closing they're writing down notes. They're saying how it all fits together. So push for it anyways. Yeah.
And a lot of times sometimes you can tell it's because they already agree with you and what you're recommending. So in that case, it might be less necessary, but it's still good to do it. And you do make a record, it's all recorded. So it's good to get that on there as well. In terms of state law, in the school code, it says a student may be expelled for gross disobedience or misconduct. They must receive notice, and that's what the notice include. So if you think about the school code, it's kind of the basic things statewide you need to do. Most schools go into more detail about their process. So that's what CPS is doing with its code of conduct. Other school districts can do it however they want as long as they're meeting these basic requirements, which are pretty basic. You just basically have to have notice and a hearing. The notice doesn't even have to be very much in advance, unfortunately. CPS is good about it, other districts aren't. The rules of evidence do apply, but it's a relaxed standard, which basically means hearsay always gets in, unless there is a case that says expansive use of hearsay violates due process, but limited use is viewed as inevitable. A lot of times that's a statement of another student. I saw this student hit this other student, or sometimes they don't want to have a student witness there because they argue it's a safety concern. Those are all ways that hearsay comes in. You can object to it. You can always object. Sometimes the hearing officer will, whatever, I don't care. Other times, I will note it for the record. The other argument we make, obviously, we don't always have the option to say they didn't do it if it's very clear that they did. And unlike in other proceedings, it can be to your advantage to admit that. A lot of schools want to see a student saying, I'm sorry, I won't do it again, I've learned from my mistakes. And so these are some mitigation factors that they are supposed to consider. So a lot of your argument can be based on things like this about their past discipline history. Is this going to affect their interest in other children? How egregious was this really? Are you doing a 2-year expulsion for something very minor? And things like that. So you can have some freedom to make these arguments, which is interesting. SMART program, and just to say that you can advocate for something besides expulsion. So the options aren't expelled or not expelled. There are these programs they can do, a Saturday morning program for CPS, which is now supposed to be available for charter schools. They're supposed to be coming up in CPS with other intervention programs as well. There are restorative practices, so there's a lot that you can say besides they shouldn't be expelled. You can try to make the argument that there are other alternatives and things that the student would benefit from. And so that's another important part of advocacy. A lot of times parents don't know that. And a lot of times CPS is like, fine, SMART program's fine. We're not going to fight you on that. Expulsion can be appealed. It doesn't happen very often. Schools give a lot of deference or courts give a lot of deference to schools. You can file for certiorari in Chancery Court. We've done it a few times. And first, usually appeal internally, so to the board president and CPS, to the head of the charter school CEO, whoever it might be. That pretty much never goes in your favor, but you do it to make a record and to show that you did it. Some charters have their own appeal process, and it might be within something like 72 hours you have to appeal the decision, which is ridiculous, but we've done it, and it hasn't been successful. We haven't brought a charter appeal to court because since the student can enroll in another school, we don't have as good an argument that their education is obviously being taken away. So there's a lot of different strategies, but usually an expulsion is hard to get appeal. So how does this work? We get an intake. We figure out, is it CPS? What's going on? Is there a hearing? Is there not a hearing? Sometimes because we have to move quickly, we might get a release right away from the parent so we can talk to the school. To get records and to get information, because they're minors, you need to get a signed release from the parent and the student, so that's the first step. Once we screen it, we send it out to our volunteers. Sometimes they have to run conflict checks, depending. We meet with the volunteer. We usually take it from there and meet with the parent and the student, and we're available for consulting, questions, strategy. You know, we're there to help with whatever needs to happen. These can go very quickly, which is the biggest challenge usually in finding pro bono volunteers. A lot of times, maybe the hearing's next week. With CPS, we can usually get the date pushed at least once. Other school districts usually too, but sometimes it's shorter. Charter schools, you know, it all depends. And so a lot of times we're trying to do this very quickly, but we can work with the school on that. Yes. Good question. So it depends. If the suspension ends while the student is still waiting for the hearing, they should be able to go back to school. Sometimes they're in an alternative school waiting for the hearing because they've been placed there because of some sort of safety concern. But so it depends. We argue that they should go back to school. There's been a couple times with other school districts we've said, in exchange for the hearing being pushed, if they can get their homework and do their assignments, and I've done this with charters a couple of times too, we'll have them stay out of school because that makes them more likely to grant the continuance for us. But that's only on the condition of them getting their work and being able to turn it in, and we don't like to do that. But if it's the difference between getting a good representation in a hearing or not. But yeah, that's really your question. So what do you think happens after an expulsion? This relates to your question. Where do students go? They just they just sit at home. Who thinks they're in some sort of other school? You already know the answer. Right. So most of the time, well, it should be all the time, but it's not. Most of the time, a student gets placed in alternative school.
Most of the time it's CPS.
Yes. So CPS does this pretty much all the time. But according to the way the law is written, it says an expelled pupil may be immediately transferred to an alternative program. And it must be denied transfer because of the expulsion in case of a safety threat. So what's happening is in some school districts, and mostly we've seen this in the south suburbs, they're not putting the kid in alternative schools. They say, the way we read this, we don't have to do it. We're not going to pay for it. And we do have one client who just 2 days ago, after like 2 months of fighting with the school board, we're getting them to alternative school. But he was a 7th grader who literally was sitting at home for 5 months and had no school whatsoever. So that does happen. And those are the students we're trying to catch. And we're also considering how we can change this statute, because the fact that some kids are just literally getting left out there and have no education services, and it's supposedly allowed, is a huge problem. Alternative programs can refuse to accept programs if they're deemed a safety threat. It's kind of a weird thing to say because most of those programs are designed for students like that. And you can't directly enroll in a school. So you can't go up to the alternative school and say, I want to go here. The district has to facilitate that, and they have to pay the tuition. And so one of the arguments with our current client was they were trying to say, well, if the family pays the tuition, then they can go, which obviously the family can't afford. Otherwise, they would probably be in another school situation. So that's an issue that I think most people aren't aware of, and that's been These are some of the organizations besides ours that provide these services. And then we're just going to take 5 minutes. And if you just want to talk to someone next to you, again, groups of 3, and read this scenario, and then we're going to talk about what we can do, what evidence we would need, and how you would prepare for this hearing. Take a second to read it, and then if you want to just grab the easiest person next to you. It's actually a combination of a couple different. Okay. Yeah, I figured this one would be because the video is really dark, so it's like I can't see it. Leo. They can edit that out. Oh, okay.
The administrators association.
I don't know if there's any.
Okay,
I don't know, like,
so probably it's gonna be
That can be brought in.
a very serious or not serious
So that's going to be
group
group 5
5,
or 6.
Yeah.
and in
I
that
think
case,
6 is violence, 5 is
okay, or illegal, illegal, most serious, so in that case, we should ask, obviously,
And are there like?
yeah, we should talk.
Yes, it's illegal and most serious.
Violation. I'm sure they can go to someone's website, but I don't know if that's.
The student is,
Yeah.
well, we need to know
Just
first.
because you're small, they have nothing.
It does not say, but
That's not how they.
Yeah.
Yeah.
maybe it doesn't matter. We know that they're not pre-K to second grade, so as long as they're older than like 8 years old, the no suspension wouldn't apply. So are you asking whether that's in charge of juvenile?
No, it's in group 6, required for students in grade 6 to 12 may be required if they're in grade 5 or below. So if they're kids in grade 5 or below, they may get an expulsion hearing, but don't necessarily have to get one.
We can probably assume the person is 12 years old.
I don't know the amount of
But
it.
it's
Right.
So
Okay.
that.
12 is 6 versus 7, 14 years.
So they need to be given notice.
Okay, so students charged, students suspended, referred to expulsion, administrators told the parents. Okay, so you're saying they need to be given notice prior to suspension?
Prior to the expulsion.
So then they want to refer to
And now the question is whether or not what the parents should do in response to the administrator's suggestion. Well, obviously, we will disregard that suggestion and go through.
Yeah, exactly, because they also.
Unless, of course, they want to allow him to withdraw and then put him outside their school. Which we have a facility.
And I don't know, like.
Well, no, yeah, exactly.
So it's either going to be push for the alternative school option, which, quite frankly, I don't think this is such a disruptive. I don't think this behavior is so disruptive that the kids should get yanked out of school. And if he had a series of things that you can't come back from, whatever circumstances don't allow you to read yourself on one instance of drug use, I don't think it's necessarily going to be your
Right,
reputation.
I mean, text messages supposedly.
Well, I mean, if they took the friend's phone, they went through the friend's
All right, so
phone,
let's
something
come
that
back
sounded
together.
like-
Everybody ready to save their kids?
All right, so let's just go really quick each group what you talked about.
recommended our kid for execution. Sorry.
Or maybe a shoe.
Some can't be. Well,
Yeah.
we tried.
What?
We
Clog
tried
for the
throwing
head.
footwear.
No, we would advise the parent not to just draw their child. We would push for hearing. We would want to be sure, first of all, what it was in. We would want to know if they received notice of a potential hearing. If not, then we would put gray area.
Yes.
Back there.
So yeah, the age of the kid is beneficial, but
Yeah, I probably should assume it's. Most of our cases are high schoolers, but we do see sixth, seventh, eighth grade. I don't think we've seen younger than sixth so far. Other thoughts?
We came up with a few things, but like we don't know the exact law, but the text messages, having some friend come up, I don't know if that might be like a hearsay thing. We also have intent to sell, just because it says, well, he's charged with intent to sell, but there was no evidence that there was intent. And we also had like maybe like just because he's previously sold doesn't indicate future inclination to sell, and then he has a right to hearing, and then so just kind of
Yeah, that's what I mean. Other thoughts? Agree with you. Sadly, well, not always.
Because the friends got these texts. If so, what was his punishment? Or did he get yours?
or can you completely suppress it because it says the text message is supposedly related to the sale? If they were speaking in weed code or whatever, whatever the kids call it. Whatever the kids call it.
I think that's what they call
Is that what they call it? Weed code?
Yeah.
I'm not cool. I'm sorry.
Yeah.
Especially when you're looking at text messages in Facebook.
Right.
It's totally coded. And they're
Right.
like, we obviously know that means marijuana. I'm like, I don't know what that means.
Yeah.
I don't think we do.
Yeah, they're hip to doing those closely. Any last thoughts? So those are all actually really good points. So here's this is a combination of a few different things. We didn't really go into like searches and stuff like that, but in schools it's pretty relaxed. We have seen a lot of cases with text messages. We try to argue about how they get to them. We usually lose, but they do sometimes take one student and get them to give up the information, and then they don't get referred for expulsion, perhaps, and the other kid does. They won't give you information about the other student, of course, because you can't get information minors, and so even though you try to conjecture and you go off what the parents are telling you about what they know happened to the other student, it can be pure guessing. The intent to sell usually pushes it up to a higher violation, and we've argued about what actually shows intent to sell and what doesn't. Kids and Facebook and other things now like Instagram, wherever, it's a terrible thing because there have been pictures of them, smoking, doing whatever, a picture with a BB gun, and then they tell the other student, I need permission because you're using our network or whatever to go on your Facebook. They see some sort of message that brings them to the Facebook wall. They see these pictures. We've seen Facebook pictures introduced at hearings. And so these are all things that we tell them, stay off social media and don't put this stuff up there. But of course, these are, young people, and so they're not thinking, oh, if I put this picture up, it's going to show up in an expulsion. But these are all things that we have to deal with and kind of unique to this situation. Hearsay, I would agree with the text messages. Usually they let it in, but at least you can object to it. Sometimes you can get around it. So those are all the issues that come up when you're dealing. Yes.
So we had a question around the school administration do anything about.
Yes, thank you for bringing that up. So we see this happen, and it's technically not improper, but it's a practice we really don't like. A lot of times, especially with other school districts, it's like, you don't want to go through the hearing, just take the kid out. You can put them, in this alternative school. You're probably going to lose the hearing, so you don't want to go through that. We really object to that practice, and as soon as a parent calls us, we're like, don't do that unless you want to. A couple times we've seen it done with charter schools, just because sometimes they don't even want to go there anymore, and the charter will drop the hearing if they enroll in a CPS school. You can sometimes negotiate things like that, but it's really something we don't like, and we actually just got a call the other day about exactly that, where they want the kid to do a correspondence school, and he's a senior about to graduate, instead of going through a hearing. So they should demand a hearing if they want one, and the school just has to deal with it because that's what they're required to provide. So yeah, that's the other point about this scenario. That happen way too often.
Right. And one of the problems with that is that if you get an expulsion, you're deemed not in good standing, and so other schools will see that you're not in good standing and not accept you. So it is this terrible thing that if you do get expelled and you do fall out of good standing, you can't go to any other school other than an alternative school, which your school district has to refer you to, and if they don't want to pay for it, they're just out of luck. So I do think it's a real thing that school administrators are saying that. The problem is what they fail to say is even if you withdraw, you probably can't get into another school either unless you move, because the only district in which you can go to is the one for which you live in, and we won't take you, so I don't know who else is going to take you. It's sort of like, well, then you can just figure it out, but you won't have this on your record. So sometimes parents come to us, I think, with a plan saying, I'm going to move I'm sending my kid to this other family member or something, which has its own share of problems as well, because some school districts are really paranoid about people sort of flooding their district and using up all their wonderful resources. And so they have like private investigators that they hire to make sure that kids actually live where they say they live, and that they're with people that are actually like caring for them, and not just doing it for the purposes of school. So it's a much more detailed analysis about whether that's something you want to do than what schools will let off. So it's really something, it really takes, talking to your client and really understanding what they want, and what's working best for them.
Right, so in that sense, if they're going to make that decision, we want them to be informed about what they're doing, and most of the time they're just like, okay, we'll sign this, and then that's it. So now Lee's going to cover just a few special education things, and we'll have time for more questions. Discussion.
Okay. And also, where's the clicking?
We've just been
using
clicking the mouse. You can hold it if you want.
All right.
Sorry.
So hi everybody, my name is Lee Robbins, and I'm a staff attorney and an Equal Justice Works Fellow at Equality. And just to add a little bit more context to what we've been talking about today, my project at Equip focuses on needs who are K through 8th grade. So I'm actually working exclusively with young. And it's really interesting with that group to see some of the issues with school push out, particularly since there are things in place that say, okay, you probably shouldn't be suspending a 6-year-old, you probably shouldn't be expelling a 6-year-old. But what I do see is a lot of scenarios where these children are still being removed from school. So for example, I have a lot of families that I work with who will get a phone call every day to come get their child. And many well-intentioned parents thinking, well, I'm going to be a good parent, they'll go get their kid at school. So I just wanted to add a little bit of context about if these removals are still happening, even if in sort of an informal way. What am I doing?
Not really a clicker.
Okay. You can use space bar too.
Yeah. So a lot of technology. And there it all goes out.
Okay. So I mean, we'll just roll. I don't know what the technology is going to do for us. But we already talked about how 10 days is a pretty important number as it relates to school discipline. Within the context of children who have an individualized education program or who are eligible for special education services, this number actually has additional implications for special education law as well. And I'll also just say before I begin that even though these students have additional protections per special education law, all of the codes of conduct and additional measures that have been put in place also apply. So if you take a look here, a student with a disability may be removed for no more than 10 consecutive school days for a disciplinary violation, so no consecutive school days, or more than 10 days that constitutes a pattern of behavior. And I'm going to go into more detail about what a pattern of behavior would be, unless an exception applies. So they can be removed for what are called 45-day removals if one of these situations arises. If there's a weapon involved, if there are drugs, or if there's serious bodily injury. And I'm going to talk again more specifically about what each of these mean. Do you have a question?
Yeah, I just wanted to back up.
Sure. So there are actually specific considerations under the Individuals with Disabilities Station Act. There are 13, sometimes 14 categories of eligibility, and those are all really spelled out in the law. And so in order for these protections to apply, you would either have already been found eligible for special education or one of those categories, or I am going to talk about a little carve out in the law for students who, because of the notice that the district would have that they would be eligible under the law, they could also get these protections as well.
So would ADD be considered?
Sure. If a child had ADHD and was found, there's a category that they're frequently found under, which is called other health, for example, and they had been found eligible under that category. So I'll go a little bit more in detail about when a student with a disability can be removed to one of these 45-day placements. So when we think about a weapon, dangerous weapon, that's not just somebody's perception of what a dangerous weapon is, it's defined within a statute. Same with drugs, what a controlled substance is. It does not include legally possessed or used substances for understandable purpose. And then serious bodily injury is also very specifically defined. It's interesting to note that these are not special education statutes, and a lot of these laws definitions of these terms. So when we're thinking about a weapon, this can get really interesting because a dangerous weapon means a weapon, device, instrument, material, or substance, animate or inanimate, that is used for or is readily capable of causing death or serious bodily injury, except that such term does not include a pocket knife with a blade of less than 2.5 inches in length. Yeah, so this can get very strange when you're having a conversation with a distraught parent and, you know, my gosh, my kid brought a knife to school and, you know, it's terrible. But you say, well, actually, can you go ahead and measure that knife for me, please? Because, you know, different considerations might apply. Next, serious bodily injury. We were really nervous as special education advocates when this piece was added because you can imagine a scenario where some school district official or administrator might say, oh, well, he caused serious bodily injury. But as things have been read into the law, this actually needs to be a very serious bodily injury. So we're not just talking about a scenario where somebody would, you know, get in a small fight, or even situations where, you know, there's a broken bone. We're talking about things like protracted and obvious disfigurement has occurred, protracted loss or impairment of the function of a bodily member. So this is a very extreme situation where this would occur, and it's very rare. So let's talk about, can a student with a disability be expelled? And for a moment, let me just back up and say, so with what we were talking about with the 10 days and the 45-day rule, you know, as it applies to the work that you'll be doing, if you do see a situation where, you know, a student has an IEP, or any student actually, and you start noticing that 10 days, that's when I would keep in mind, okay, is this a situation where some of these extras. I'm going to talk a little bit more specifically about whether they can be expelled and what are the situations where that can occur. So the quick answer is yes, you can be expelled if you are a student who receives special education services, but during the expulsion, and this is different for special education opposed to students who are in the general education, educational services must still be provided. So what Jess was talking about earlier with that situation where a kid could be potentially sitting on a couch for up to 2 years, not being educated in an alternative setting, Students with IEPs must still be participating in the general education curriculum, and they must be progressing toward meeting goals set out in their IEP. So before an expulsion can take place as well, another protection is in place, and it's called a manifestation determination review. And a manifestation determination review is essentially a pretty informal meeting that will take place at a school. And it occurs after a school suspends a student with a disability for 10 consecutive school days, or, and this is where I'm going to talk more about what a pattern would look like, where more than 10 days in a school year that constitutes a pattern have occurred. So basically the IEP team, it can be administrators, social workers, special education, they will sit around and they'll talk about whether a student's behavior is a manifestation of his or her disability. And I'll go into detail about what that means, but I also first just want to talk about this idea of pattern. So if we have 10 consecutive days of school days removal, that's pretty easy to understand. But when we're looking at a situation that constitutes a pattern, typically the way that that's read is a pattern of the behavior of the student. So if you have a student that is removed for 4 days related to skipping class, and the rest of the days, 7 days related to fighting, that's not necessarily a pattern of behavior. It would be a little bit more difficult to say you would have to hold an MDR in that situation. But if in both instances, even if they didn't occur in 10 consecutive school days, if both instances involve the same type of fighting or the same type of behavior of the student, it's a much stronger argument that even though this is not 10 consecutive days, that there is a pattern that's occurring here. I will say that in any situation where a student with an IEP is being removed for more than 10 days, whether it's a pattern or not, as an advocate, and I advise parents, we're going to call an IEP meeting to talk about what's going on here, because clearly if there's specialized instruction and behavioral supports that are supposed to be put in place for this student and this is happening, something's not working. And so you can really use that as leverage as well in these types of cases. So I'll talk about these manifestation determination meetings and basically what is or is not a manifestation of a student's disability. So there are 3 scenarios where a behavior is considered a manifestation of a disability. And these are ors, you'll note, so you don't have to say that all of these must apply. So the behavior must be caused by the disability, or have a direct or substantial relationship to the disability, or be a direct result of the school's failure to implement the student. And I will say that districts are not quick to say that this third standard applies. I have seen it in certain situations where perhaps a student transferred and for whatever reason the paperwork didn't follow that student, and the district was wrongfully not aware that the student had an IEP. But that's pretty much the only scenario where I've seen a school district say, oh, this is because we weren't implementing their IEP. These other situations are ones that I can argue for more frequently. So you can imagine a situation where a student has a mental health issue or an emotional disability, ADHD, for example, and they're off task in a situation and that led to a behavioral incident. It's pretty, I don't want to say easy because you'd be surprised, but you have a stronger argument in that scenario that that behavior was caused by the disability or was a direct or substantial relationship to the disability. So if the student's behavior is a manifestation of his or her disability, they can't be expelled without parent consent, and they must be returned to the pre-removal placement. But again, this doesn't take into account those situations where those 3 exceptions apply for the 45-day removals that we talked about. So, okay, so we say we're not going to expel the student. They have a disability, and this behavior was a manifestation of that disability. What are we going to do for them? Well, we can't just send them back into the classroom and hope that things go well, right? So there are mechanisms in place for a situation where a behavior is found to be a manifestation of a student's disability. Basically, a functional behavioral assessment is going to be done. And what that is it's an evaluation that the school does to show the relationship between the student's behavior and what happened. So you're literally observing that student in the classroom, tracking their behavior, and trying to figure out why it is that that behavior is happening. A lot of theories suggest that every type of behavior has a function. There's a reason behind every behavior. So within an FBA, that type of analysis is done so that we can be more proactive about addressing behaviors for students with disabilities. And then finally, in response to that analysis, a behavioral intervention plan is either created or revised. And it's supposed to have positive interventions. A lot of what we've been talking about today are those more punitive measures that are taken into account. We're going to suspend you. What we found in research is that with students, especially students, with emotional issues, they respond much better to systems of rewards or positive praise that occurs for their good behavior, as opposed to being put in a situation where you're just being sent out of school and maybe you don't like school anyway, so that's kind of a reward. And so it's really thinking more critically about the different positive interventions that we can put in place in the classroom. This type of behavior doesn't happen again. In the scenario where the district says that this behavior is not a manifestation of this disability, so what happened here had absolutely nothing to do with the disability. The school can use the same discipline measures that they would with the general education student that we've already talked about. However, and this is the exception we just mentioned, if you are, for example, expelled, you will still be sent to an alternative school so that you have access to your free and appropriate public education. That's something that is required for students who have IEPs. So our appeal process for disciplinary removals is a little bit different because when we are appealing a disciplinary removal like an expulsion, we will file for an administrative due process hearing. And that hearing is actually expedited. So there are no continuances. It happens within 20 school days from a request, and the decision comes out in 10 days. That said, what I'll say is I've personally never done one of these expedited due process hearings, and they are rare because so often we'll settle. Because as you might imagine, both sides aren't necessarily anxious about preparing for hearing within 20 school days. And so there is a mechanism in place, but a lot of the time this actually offers a lot of leverage for negotiation. I mentioned this earlier when we were talking about eligibility. So all of the protections that I've talked about are not just available for students who are already found eligible for special education services. And this is really great because, as you can imagine, we've already talked about, there are a lot of kids who don't have IEPs yet who may need one. They may be going through the eligibility process. And so there's an understanding in the law that they should still get these protections. And how they would get that is if there's some sort of notice to the school district that this is a child who may be eligible for special education services. If a parent has already stated in writing to a supervisor, administrator, or teacher, I think my child needs special ed. If there's been an evaluation requested, or if a teacher or staff has expressed specific concerns about a child's pattern of behavioral directly related to special education, or they've told an administrator that. And what I will say is it's unfortunate in a lot of the situations with parents that I work with, they may have mentioned something in passing to an administrator, but that's really not the same as writing out a formal request for an evaluation. A lot of the time what we say is if it's not in writing, it didn't happen in this scenario. So definitely this applies in rare circumstances, unfortunately, not always written down. So we already talked about this before. Typically, students who are expelled go to alternative schools. There's some important distinction to be made between the schools for students who are, don't have a lot of credits and who are just trying to finish quickly, who are in those types of settings, and schools that are really for alternative educational programs. But the important point is that they won't be sitting at home and making out on the street during this time. I already talked about this a little bit. My advocacy strategy for students with disabilities when it does come to a situation where we have one of these cases come up for hearing is to try to resolve it as quickly as I can prior to the hearing even happening. A lot of the time I can resolve this issue by sending a demand letter and using the child's individualized education program as leverage to get them something other than an expulsion. So for example, you can say, well, wait a minute, this IEP wasn't being implemented, or we know this about this child's disability, and X, Y, and Z services were never offered to that child. So instead of removing them from school, let's talk about the ways that we can provide them with special education services and supports through this plan that you've already acknowledged that they need in order to effectuate a better situation for everybody. We already talked about the mitigating factors before, but if the case does go to hearing, we're always prepared to present that mitigating evidence to illustrate, there's more to this child than individual incident. So this is my contact information. You can feel free to contact me if you ever have any questions related to special education. That said, if you do, in your cases, have a special education issue that comes up, I would advise you to turn to your fearless leaders at Lawyers Committee to see if that's something that you maybe should consider referring to Equip for Equality.
Yeah, and so the reason that, it's not always a perfect separation of the special ed issues and the non-special ed issues. That's why we really value our partnership with Equip and other agencies. We have occasionally, Candace did do a manifestation review once, but we don't have the expertise. And as you can see, there are a lot more protections. So if you can go that route, that's the route you want to go. And sometimes parents don't want to do that because they're like, well, my kid doesn't have a disability. But it's just such a broad definition, and a lot of kids, if they're exhibiting this behavior, it could be because if they've offended multiple times, but sometimes you don't know that from the outset. And they have their own training and volunteer pro bono pool as well. And also, it's just good to be aware of those issues in case they come up.
Another thing I'll add is sometimes because of all of the protections you get under special education, sometimes in the representation that I'll advocate for similar things, and granted they don't have to do it, but it's easy to say that I know you do this, I know you have this available, I know you can do this. Let's extend this to this child because we know that they're going through this, or especially when we're dealing with behavior issues. If we can show consistent patterns and we see that from the record, did anyone stop and have a conversation about if there's a special education issue here? So it really does sort of involves a lot of the work that we do, and I feel like a lot of times we're at the point where we're trying to push for identification or even just additional consideration.
Yeah.
I think it really strengthens our case. Otherwise, we're sort of in this really interesting gray area where we're negotiating, we're making a lot of just sort of sound, good moral arguments. But I mean, I think we really are in a place where until we get under like special education law, they don't have to do a lot of things, but they should.
But they should, and it's still best practice. I mean, when I was teaching, we always talk about how special education, a lot of the times just like good education or individualized education. So, I mean, a lot of these things can be put in place, and it's exciting when there are reforms in student codes of conduct, where a general education student might have a behavior intervention plan, which is, typically thought of as a special education initiative, but it doesn't have to be something that's done through special ed. So I think to the extent that you can just be creative in those ways, there's a lot of room for.
Yeah, there's a lot of room for creativity in the discipline field.
Yeah.
You can just kind of get in there and see. Like Lee was saying, I mean, if things are going well, we're never going to get to an expulsion hearing, which sounds weird because then we're kind of putting ourselves out of business. But there's so much advocacy that can be done before you get there, or negotiation, or creative strategy. And then the kid that I was saying was sitting out of school for 5 months, and now we finally are going to get him an alternative school 1 semester before he goes back. The opposing counsel told me that because of what he did, the board believes he forfeited his right to a public education. And I was like, I'm going to use this quote. You won't even know how many times, because that is the most ridiculous thing I've ever heard. So that's out there. I mean, with some of these offenses, it's seen as so bad that somehow this kid can't ever go back to school, or can't for a year and a half, which essentially for a 13-year-old kid is saying, good luck, you're probably going to drop out, because how is he going to be able to catch up back in his peer group? So it's a very real problem, unfortunately.
It's startling, and how many of us would like to be held accountable to that level for the things we did.
Right.
That
too.
Not me.
And another thing, one of the reasons why there isn't a ton of law on the special education side of school discipline is because a lot of these cases do settle, and districts will sort of drag, they'll fight you all the way to the point in which you file something, and then they'll back off of it because what you're asking typically is relatively small to any litigation costs that they're going to have. It's always really surprising to see the schools that want to just fight all the way through litigation, because you know this is costing way more than whatever you're typically have them come back to school, put them in an alternative school, and we're talking maybe that semester. So it's unfortunate, I think, for us, because it's really hard to get that good precedent that we want and really to make those cases in court. Mm-hmm. But it's in the best interest of our client, because if we have to drag through a court case, that means they're possibly sitting out of school much longer, and they're waiting that they're looking for. So it's always districts will do it. Some take a little longer to come around than others. Mm-hmm. But for the most part, there is a lot of that to go. Another thing I'll add is, so all of the things that we presented, you'll get, so don't feel like you'll be sort of left out there. We'll give you a copy of our PowerPoint. We'll send you a link to the CPS Student Code of Conduct. We also do have a manual. We didn't present it to you guys today because it's outdated right now with the changes to the Code of Conduct. So we're revamping all of that, and once you have that done, you'll have that available. But as you go through these cases, you do have us every step of the way. You can use our space if you need to have a client meeting, if you need to consult with us. Sometimes folks feel a little bit more comfortable having one of us do the cases with them. I think, and we're willing to do that. A lot of times, if you don't need it at all, this is not a super formal process, but we'll help you and make sure you're comfortable with everything. They're so appreciative. And even if you don't get what you think are the best outcomes, it really does mean a lot to them to just making their voice heard through the process, because these meetings are one parent, one student, 10 administrators. Mm-hmm. And they're all just telling the parent over and over again about how terrible their student was, or what they did was like the worst thing that they've ever seen in their entire lives. And they had this total wasteland. Like, it's ridiculous, some of the things that you hear.
Yeah, we've seen some crazy stuff.
I mean, I've seen somebody try to impeach a sixth grader.
Were you lying then or are you lying now?
What are we doing here?
And the hearing officer, every time we'd object, just wouldn't rule. He'd just be like, okay. And then we just argue. It was very bizarre. That's why CPS is good to start with, because it's very formalized, very consistent. Other school districts, you never quite know what you're going to get with an expulsion hearing. Charters are pretty, a lot of them now are represented by the same firm with, so she knows.
Folks have questions, comments?
Yep. I know that negotiations that can happen non-clear before the hearing even takes place. So just so they can understand.
Yeah, definitely. It can be a little hard so occasionally we get cases where the student has already been expelled, and we're saying either the expulsion was wrong or you didn't consider something. And I think really you enter more of an open space in that way. With a hearing looming, it can be touch and go with whether they're open to talk. But yeah, it really, you can come up with alternatives, and if parent is in agreement with it and the school is, then I mean, you can avoid it, which in many ways is a desired outcome.
Yeah, you'd be surprised what people agree to sometimes. Yeah. Because they don't maybe hasn't really thought about something as a possible. That creativity is appreciated.
If you can find outside programs or like mentoring, counseling, whatever it might be, a lot of times they're open to that too as an interest, especially if you do the work for them.
And in many respects, there are people within the school that may not want the kids to actually be. So I know a lot of times I deal with teachers who feel like their hands are tied. Like they wanted somebody to deal with whatever the behavior was, but the way that folks dealt with it was to move forward with an expulsion. The teacher actually is not against the student. That's not always the case, but you can find allies for the student within the school. you don't necessarily get the right to like subpoena people or anything like that. But you can talk, and if there are allies within the school that are willing, school oftentimes tries to introduce letters to students about what happened. So if someone else is willing to write a letter, they're introducing letters, I'm introducing letters. If your hearsay is coming in, mine is too. So,
Right, so then when you object, you're like, well, they're gonna raise the same objection to mine, but it's fine.
well, because I mean, a lot of times it's going to be overruled, and then so if it's overruled, I'm throwing it right back at you. So
These hearing officers experienced in litigation.
everyone.
Well, CPS has their own hearing officers that are pretty good, at least in doing a lot of them are just like retired, whatever. And they have done a lot of these hearings. Some of the bigger charter networks also hire their own hearing officers. Less experienced and effective. School districts, it can vary. They can use someone from the board. They can use, so there you're in pretty much, not a territory in terms of experienced hearing officers. Or impartial, which we've also argued at times that they're not impartial, part of the district and part of the school system. But so it can run the gamut, but at least in the CPS hearing. I mean, they're also employed by CPS, so there's that question, but they just do the hearings, at least contact with the student or what they did. Or
some are really experienced in litigation. Others, I mean, I'm pretty sure they didn't know what I was saying when I said you said. Like they're just kind of like, I'm just gonna let them talk. And I was like, wait, what's going on?
Yeah.
So
or one, he wouldn't let it. They were introducing the statements. They wouldn't even let us see them or read them while they were reading them into the record. And sometimes they redact. They're supposed to redact other students' names for privacy reasons. Sometimes they do. Sometimes like they redact them, but you won't see that. Problem usually with.
Some experience dealing with school districts for process issues like zoning or something. Is that true with this education? Something. And just do
Yeah. So the hearing officer makes a recommendation based on the report from the hearing and I heard. Technically, the school board is who decides. So they almost always just approve the hearing officer's recommendation, but they have to put their stamp on it. So in CPS, again, because it's such a huge district, they're sending it to the board, and it's just a formality. There are no board members at the hearing. But in other school districts, it's the board who's deciding on the outcome, and it's usually just made up of elected who might do whatever.
Is there any like punitive things? If they, like,
Yes, unfortunately they did. They followed. So they have the district will have an attorney, and so if they're involved, they'll tell them all the things they need to do for this. And so they followed everything they needed for due process. Got expelled, and unfortunately, the family came to us well after the hearing, so we couldn't represent. But we went through all the documents, and there was nothing that we could pick on really in due process. They followed all the minimum requirements properly. It was just really unfortunate because the district was represented and the student was not. And so there was really, we do look for due process violations, and if we can find them, that's ideal. But they're pretty rare because most districts have this down. And so, we went to a board meeting Monday night. It was just all these regular people, again, trying to propose to have the district enroll him in alternative school. And it's annoying because you have to deal with the board structure when the board meetings are and the board has to vote on it and they only meet at certain times and it just gets really difficult to deal with. But yeah, you're right. You could look for due process violations.
And I think some of the common ones that, I mean, they're not common that they come up, but if there are, sometimes I've seen they don't have any record of the hearing. They just have the decision. That's pretty rare, but when you don't have a record, it's pretty easy to make an argument they violated due process. Not giving the kid or their family any opportunity to speak or really confront evidence, and confront is going to be sort of touchy because, again, sometimes they do bring letters of students who aren't there. I always argue that, you know, how do we know if we can't ask these people questions? Their statements should not come in. Sometimes you win, sometimes you lose with that. But I think especially if you're appealing in a decision, that can be taken a little bit more serious. And especially maybe if you're going to go to court on a case, it's something to bring up. So, and then notice, obviously, most districts are really, but if you ever see that they didn't tell them that they have a lawyer, I mean, that's pretty obvious. And then to your point about a student being out of school for a period of time, sometimes I'll ask for compensatory education, so to make up for the time lost. And this is usually going to be in the form of like some extra tutoring school at the district's cost, because they'll say, oh, they can go to summer school, but they need to pay. Oh, this is your fault. They're not paying. So I think that's some of the creative things. So thank you all for coming. You'll be part of our volunteer pool. The way Jessica talked about this, we sort of send an email out about what a case is involving, and to see if someone's interested in it. And you let us know if you're interested. We'll talk about running conflict stress and everything. We'll give you a lot of those resources that we put up today, and then once we have that hearing. So look out for us. Please take some of these cases. They're really good. They're pretty quick, and they're really rewarding. Thank you so much.
Yeah.
No, actually, I had mine in like 2 hours.
Oh, it's in 2 hours.
Yeah, it said maybe a little bit more. But yeah, it said 1. So yeah, well, I mean, the truth is, I found this last Friday and I didn't get the response back to it yesterday afternoon. So
Everybody got a chance
if they had caught me 80 later, I absolutely would have.
Yeah.
But now that I'm downtown, I can just walk over to school, knock out another hour or so maybe, and then
It's not your first year, it's your last year, right?
my last semester. Next semester is my last semester.
Sorry.
I'll see you at DLA.
Yeah.
Anyone wants more coffee or another bagel?
Or not.
Or not, I mean, I gotta get my prom in my ride motorcycle.
Oh. You need to talk to that man.
Oh, really?
Yeah, because he volunteered hardcore on his bike.
Yeah, I have no problem doing that.
I know.
April and October.
Yeah.
But like if I'm riding down to
But like,
26
what
in
you said is
town,
You want to go to 15
that's
no, don't get me wrong, I'm not a, you know,
No,
I'm not a
no,
punk
but
rocker.
no,
Yeah,
we
this is
don't.
like-
I mean, 26 in Cali have already been charged. But
Cases,
Jason,
so.
well, like at 2 in the morning, you jump on his bike from Northbrook to like Belmont and Western.
That's no joke. No, Belmont and Western.
That's why he got an
I
all-star
can walk to
status.
Belmont and Western. That's no big,
Yeah.
no big deal at all.
So we like people
What,
riding
she's-
bikes.
oh,
too.